For those who do not know the Rule of Law Development Foundation, it is a non-governmental organization which was established 10 years ago to today, which seeks the enhancement of not only criminal justice, but civil society and Nigeria at large. And for 6 years running, the Rule of Law Development Foundation, under the leadership of the coordinator, Chief J.B. DAUDU, SAN, has been organizing this gathering of various legal minds and experts for us to dissect, digest, provide solutions to the various bottlenecks affecting administration of criminal justice. Permit me at this stage for us to start the program before I introduce our guests with the national anthem. So can we stand up for the national anthem, please? Technical, please.
Nigeria, we hail thee, our own dear native land. Though tribe and tongue may differ, in brotherhood we stand. Nigerians old and proud to serve our sovereign motherland. Our flag shall be a symbol that truth and justice reign. In peace or battle honored, and this we count as gain. To hang on to our children a banner without stain. O God of all creation, grant this our one request. Help us to build a nation where no man is oppressed, and so with peace and plenty, Nigeria may be blessed.
Thank you all. You may take your seats. Once more, distinguished and referred ladies and gentlemen, you are welcome to the annual Criminal Law Review Conference, and we are at the opening ceremony. Permit me to start by introducing and recognizing our special guest of honor and keynote speaker. Please permit me to recognize Mr. Olanipekun Olukoyede, the Executive Chairman of the Economic and Financial Crimes Commission. We also have with us the coordinator of the Rule of Law Development Foundation, a past president of the Nigerian Bar Association, Chief J.B. DAUDU, Senior Advocate of Nigeria. Please, let's give him a round of applause. We also have remotely heads of court, and some of us might have noticed KOGI State is also in the room. Our colleagues in KOGI State, I don't know if we can hear us. Those live in the government house in LOKOJA at the banquet, I will introduce the Chief Judge of KOGI State, Honorable Justice J.J. Majebi. Please, let's give him a round of applause. We also have the President of the National Industrial Court of Nigeria, Honorable Justice Professor B.B. Kanyip, ably represented by Honorable Justice Olufunke Anuwe. Please give her a round of applause. We also have with us a justice of the Court of Appeal, retired but not tired, Honorable Justice M.A.R. Oredola. Please let us give him a round of applause. We understand we also have other judges here present. We have in the building Honorable Justice Hadiza Suleiman of the High Court of Kano State. I don't know if my Lord is here present, and if my Lord can be ushered to the high table, please. My Lord, you are very much welcome. If my Lord can be ushered to the high table. We also have other justices remotely joining us from Kogi State. We have Honorable Justice A.N. Awulu. Let's give him a round of applause. Honorable Justice M.E. Umar. Honorable Justice Moses Guatana. Honorable Justice Salisu Umar. And Honorable Justice A.O. Salihu, all of the High Court of Justice of Kogi State. We also recognize the Honorable Attorney General of the Federation, who is no other person than Prince Lateef Fagbemi, Senior Advocate of Nigeria, ably represented by the Director of Public Prosecutions, M.B. Abubakar. You are welcome, sir. Also permit me to recognize all the way in Kogi State, but following us, the Honorable Attorney General of Kogi State, Muizuddin Yunus Abdullahi, Senior Advocate of Nigeria. Please, let's. We also have with us, joining us online, the President of the African Bar Association, AFBA, Ibrahim Edimak, Esquire, also a former General Secretary of the Nigerian Bar Association. Let's give him a round of applause. It's not easy to have the President of the African Bar Association also join us. I understand that the President of the Nigerian Bar Association will join us shortly. We have also learned senior advocates of Nigeria here present. And I start with the former General Secretary of the Nigerian Bar Association, Are Olumuyiwa Akimboro, Senior Advocate of Nigeria. We also have with us DC Ewelum, Senior Advocate of Nigeria. We have O.M. Atoyebi, Senior Advocate of Nigeria, also here present. We also have Abdullahi Yaya, Senior Advocate of Nigeria, here present. And Adeodayo Adidiji, SAN. There might be other senior advocates that have come into the room. I will take recognitions as they come. We have other partners with us here present. We have chairmen of branches also here present, are representatives of various branches. Particularly, I recognize the chairman of Banawa branch, who is here present, Madam Bukola Ajau, here present. We also have represented in the room the Medical Guild of Nigeria, and we have Dr. Gumbo here. Dr. Gumbo, are you here? Please, let's give him a round of applause. And I recognize other partners in civil society, distinguished ladies and gentlemen, gentlemen of the press. You are welcome to this opening ceremony of the Rule of Law Development Foundation Annual Criminal Law Review, where we have said that we are going to be looking at the hottest and latest and burning issues on criminal law. And we have this year no other person than the EFCC chairman, the executive EFCC chairman, to give us the keynote speech. We have an array of various guests who will do justice to the topics here presented. And we have others joining us remotely, both within here and even at the car park. And so at the various points in time, I'll be calling on very interactive contributions from all resource persons here present. Permit me at this stage to invite for his opening address the coordinator of the Rule of Law Development Foundation, who is no other person than Mr. J.B. DAUDU, Senior Advocate of Nigeria. Please, let's give him a round of applause as he addresses us on why we are here. Thank you, sir.
May I, first of all, apologize that we started late. It's usually not in our character. We had to put certain logistical situations together and our special guest of honor, chairman, executive chairman of the EFCC, had to cut short his trip, traveled from abroad to be here. So it only behoved on us to wait for him to come in after landing this morning. Chairman, you're very welcome. My welcome address, you may find it a bit lengthy. I apologize in advance. The issues of the moment, but it's supposed to set up the tone for the conference itself. I will just take a few of the protocol. I've already recognized the executive chairman of the Economic Financial Crimes Commission, Mr. LOKOJA. I had set out a protocol order in my speech, which will be circulated. I would just say at this point that I stand on the protocol list and order ably set out and identified by the MC, Mr. P.O.W, SAN, whose protocol list I adopt. So I trust you pardon me for not going through the tedium of repeating the protocol list again. So I just say all protocols duly observed. On behalf of the Rule of Law Development Foundation, I welcome you all to the opening ceremony of the 6th Annual Criminal Law Review Conference, taking place from today, the 18th of November 2014, to Friday, the 22nd of November 2024. At this particular address, which is Mafemi Crescent, and virtually at various locations within Nigeria and abroad, may I use this opportunity to acknowledge and welcome the powerful, well over 50-person delegation led by the Attorney General, the Honorable the Attorney General of KOGI State, Mr. Muizdin Abdullahi SAN, participating virtual from their ultra-modern banquet conference hall in the KOGI State Government House called Glass House, LOKOJA, Nigeria. The Criminal Law Review Conference commenced 6 years ago. As one of the flagship events of this foundation, and it was essentially to promote an annual forum for the review of all developments, particularly novel developments in the field of crime apprehension, crime prosecution, crime adjudication, and the important activities of the past adjudicatory processes and institutions of the criminal justice system. These entailed for us, as a matter of necessity, the consideration of the state of the existing laws governing the powers and functions of the Nigerian police and all other enforcement agencies operating in Nigeria, as it relates to the courts, while acknowledging the strenuous conditions under which our courts performed their onerous duties. The Foundation annually, and still does as a matter of policy, reviews the recent cases and decisions of our law courts, particularly the Supreme Court and the Court of Appeal, on virtually every area of criminal law and procedure, on which they pronounce judgment within the time frame under consideration. One of the cases to be reviewed is Nigeria 4 against FRN. Sure will be of interest to the chairman because they are now mandated to record all statements made by accused persons. So views for and against will be taken in the course of the conference. It is also part of the conference mandate to highlight any legislative developments emanating from the National Assembly of Nigeria and any of or all the 36 states houses of assembly in Nigeria within the period under review. A clear example is the domestication by most, if not all, of the 36 states of the Federal Republic of Nigeria of the provisions of the Administration of the Criminal Justice Act 2015. We have over the years considered the implications or effects of all criminal bills sent to the National Assembly within their legislative incubator and have, within our understanding, suggested possible modifications to such bills or portions thereof, advise them on it before the ultimate passage of those bills while they are still in their unrefined form. A further mandate of the conference is to review the progress and performance of our correctional institutions. The Foundation takes the view that the correctional institutions are pivotal to the success or smooth operation of any socio-economic, political, cultural, such system, such as the Nigerian state. The Foundation cannot be faulted when it takes the view that our correctional institutions or prisons, as they are better known, are in a decrepit state and in offensive conditions of squalor and disrepair. They, in our view, constitute a serious health hazard to the inmates therein. In our humble view, as a result of the growing crime rate in Nigeria and the corresponding instability generated by such wanton acts of insecurity and criminality in every nook and corner, cranny of the nation, there is a need for the government of the Federation and indeed state governments, and in bracket, pursuant to the 22-23 constitutional amendment that placed correctional centers and prisons on the concurrent legislative list, to, as a matter of national priority and urgency, build, construct, or install one multi-purpose correctional center in each of the 774 local government councils in Nigeria. This foundation is of the considered view that proper and indeed effective utilization of these proposed new correctional centers will reduce, if not totally, eradicate the tsunami of criminality currently engulfing and overwhelming our dear nation, Nigeria. Traditionally, and as a matter of convention, the Foundation usually at this conference considers new developments in the following areas: substantive criminal law, criminal procedure law, substantive law of evidence, and electronic evidence. We also consider the jurisprudence arising from and relating to the powers and functions of the EFCC and the ICPC, such as financial crimes prosecution, plea bargain, and where we suspect high-handedness if any of the powers of arrest and apprehension exercised or exercisable by these authorities. We also look into the issues of recovery and forfeiture of assets, etc. Mr. Dan Enwelum usually takes that, and Chinelo Ogbozo deal with forfeiture of assets and recovery of assets, for which I must commend the FCC for doing a very good job so far. There will also be sessions on relevant topics such as the efforts of the Minister of the FCT and his security team to curb the growth of rising criminality in the FCT. Other sessions will also revolve around and include forays by tested resource persons into the areas of currency manipulation in Nigeria, cryptocurrency, and other modern methods of financial transactions and money storage. We will also examine in this part, and indeed expect to hear from our participants from the AFCC who have graciously accepted to present their position on the point, and we take it seriously, whether the fight against what is known and referred to as Yahoo Yahoo, cyber crimes, is being contained, or do we think is a lost cause? So they will deal with that issue when the time comes. I know the chairman has his facts and statistics, but I will not let the cat out of the bag. The last session is usually on Friday, and it is our own way of saving the best for the last. On this day, the conference usually deliberates on developments in our attitude to and enforcement of the laws that protect vulnerable persons, such as children, women, and to some extent, men. This Friday, we shall, God willing, discuss the topics revolving around the role and responsibility of parents, caregivers, schools, hospitals, in the management of the health and safety of children and persons suffering from one disability or the other. We shall also consider what to do with the current escalating rampancy of sexual offenses such as rape, defilement, and abduction of minors. This session should also discuss the startling and indeed apprehensive news reaching us that the Violence Against Persons Prohibition Act is being considered for repeal by our National Assembly, meaning that years of hard work and labor by civil societies and organizations to protect the right of vulnerable persons would all have been flushed down the drain. I am sure and indeed confident that the resource persons assigned to deal with this formidable task will deliver the right and indeed appropriate recommendations that will ensure the stability and protection of our vulnerable persons. In the achievement of the ideals and objectives of this conference, especially as exposed above, and in the concept note, exposed above, and in our concept note leading to this conference, the judiciary, Nigerian judiciary, has been identified as an indispensable and indeed critical / essential vehicle in the attainment of the goal of a viable criminal justice system in Nigeria. The face of our judiciary is the law courts, and the judges and justices that man them, they constitute the face of the judiciary. The ability of the judiciary to discharge its functions is rooted in the confidence that the populace, that is the people it serves, repose in it. Conversely, the judiciary cannot function, and it is not expected to function optimally in an atmosphere of distrust, political rascality, born out of partisanship and of self-interest. In a democracy such as ours, judicial independence, impartiality, and accountability constitute the engine room upon which such a judiciary is fired. Our Constitution, that is the 1999 Constitution as amended, possesses sufficient safeguards by way of constitutional provisions that guarantee the independence and impartiality of our courts. At this point in time, it is very important to draw attention to the fact that our Constitution, being a written Constitution, must be read as a whole. I humbly submit that it is not permissible to take isolated parts of the Constitution and give it a construction that suits the political idiosyncrasies of persons who apparently for personal reasons do not see any good in the judiciary or in our justice system. Since the return of the democratic system of governance in 1999, the Nigerian judiciary has been aggressively subjected to excruciating campaigns of calumny by those who consider themselves not favored by civil judgments arising from election and indeed political matters. The genesis of the situation is not far-fetched. It began when the judiciary, epitomized by the Supreme Court of Nigeria, began to move away from their decisions of non-interference in political matters, especially matters arising from or relating to the internal running of political party. This position was settled by the Supreme Court decisions in the celebrated cases of Onoha against Okafor and Dalato against Turaki, where the Supreme Court took the view that political parties are supreme over their internal affairs and that they exercise sovereignty over matters concerning issues of sponsorship or of candidates and the domestic running of the affairs of their political parties. In other words, that the internal affairs of political parties should not be a matter of interference by the law courts. These decisions, that is, Onoha and Turaki, heralded a period of judicial self-restraint, whereby despite the bombardment by politicians on the courts, or to change their course position to one of interference in political party internal affairs, the judiciary refused to budge until the politicians themselves, through one of their main organs, which is the second arm of government, the legislature, introduced the provisions of Section 34, subsection 2, Section 87, subsection 9, to the 2007 and 2010 electoral acts into our electoral jurisprudence. These provisions led to a radical departure by the courts from the position of restraint, which was epitomized by the judgments, the later judgments of the Supreme Court in Ugu against Ararume and Amechi against INEC and others. From that point, the floodgates were opened, and it became an open sesame for politicians to approach the courts on the cover of statutory license as provided by the Electoral Acts of 2010 and 2022, juxtaposed with the overarching influence of the provisions of Section 285 of the 1999 Constitution as amended. All I've said is that these provisions moved the courts from the position of non-interference in party matters, and there is now statutory liberty and license for courts now to be bogged down with cases of who is the correct party chairman, when should party parameters be held. So we have moved from that position of judicial restraint to the position of, or I will explain the consequence of this as we go on. Please bear with me. I do not intend to elaborate on the effect of these decisions of the court and provisions of the law, as that is not the objective here. The purpose of referring to them is to draw attention to the fact that it is this opening of the floodgates in approaching the courts by politicians in respect of the internal affairs of their political parties that has inundated the Supreme Court, the Court of Appeal, and all other courts with an avalanche of criticism of absence of judicial independence and other wild and malicious allegations of judicial inducement and interference over what clearly arose or emanated from historically and constitutionally justified day-to-day acts of government. In the past few months, a cross-section of the legal intelligentsia have labeled executive actions like the purchase of vehicles and other hardware, the construction of official residential quarters for judges, the renovation of courts, and the construction of new courtrooms by the executive arm of government, state and federal, as amounting to inducements and the purchase of justice from the courts. From all available empirical evidence, the foregoing allegations are untrue, malicious, and only designed to portray the judiciary in very bad light. Even though the Honorable Minister of the FCT, through his special assistant, one Larry Olayinka, have denied that there is anything untoward, illegal, unlawful, unethical, or unconstitutional in the building of judicial quarters by the executive arm of government, the same intelligentsia is adamant in their position that such a measure is illegal and unethical because it amounts to a breach of the rules of the separation of powers. To debunk this postulation, it is necessary to give a brief description of my understanding of the doctrine of separation of powers. Chairman, please bear with me. It is a basic principle of constitutional law that defines the functions and responsibilities of the three branches of government: the legislature, the executive, and the judiciary. The framework, or this framework, is designed to prevent the concentration of power in any single entity, thereby safeguarding individual liberties and promoting a system of checks and balances. This concept can be traced back to the ancient political theories, but was most notably articulated by the French philosopher Montesquieu in his seminal work, The Spirit of the Laws, circa 1748. Montesquieu argued that liberty could only be preserved when the legislative or the legislature, executive, and judicial powers were held by separate entities. He posited that if these powers were concentrated in one body or individual, it will lead to tyranny and oppression. The idea was influenced in earlier thinking by earlier thinkers such as John Locke, who emphasized the importance of a divided government to prevent abuse of power. The question to ask is, if there exists in this world a democratic system in which there is a watertight or ironclad compartment as to how the three arms of government operate. In other words, do the functions of these three branches of government overlap? About 48 to 50 years ago, I was a student of constitutional law at ABU Zaria. And our dean, Professor Manan, taught us these elementary principles. And gladly, we did the comparative constitutional law with though my senior, but he came to read masters, and we did masters comparative constitutional law. And these same principles were helped. The Honorable Justice Redala can bear me witness. And it is settled in law, as I shall demonstrate, albeit briefly hereunder, that no democratic system has a strict application of separation of powers because governmental powers and responsibilities are too complicated and interrelated to be so compartmentalized. As a starting point, it is necessary to highlight the provisions of Section 4, 5, and 6 of the 1999 Constitution, and that set out that the provisions of Section 4, 5, and 6 of the Constitution set out the broad powers of the executive, legislative, and judicial arms of government. For instance, to enhance its representational status, the Constitution further bestows limited executive, financial, quasi-judicial powers on the National Assembly. There have been frequent conflicts between the executive and the legislative branches over budget allocations and implementation. As recently as late 2023, there was significant controversy over the National Assembly's modification to the 2024 budget proposed by President Tinubu's administration. The legislature had increased the budget originally sent by the executive with over 1.2 trillion naira, raising concerns about fiscal discipline, breaches of the rules of separation of powers, and balance of power in budgetary matters. In the United States, Government shutdowns have occurred when the executive and legislative branches failed to agree on budget appropriations. You remember the 35-day shutdown in 2016, 2018 to 2019, the longest in US history, resulting from disagreements between President Trump and Congress over border wall funding, illustrating how budget conflicts can paralyze government operation. Under Section 88 of the Constitution, the National Assembly is vested with powers to conduct investigations into any of the matters on the exclusive and concurrent lists of the Constitution, and the conduct of affairs of any person, authority, ministry, or government department charged or intended to be charged with the duty or responsibility for executing or administering laws enacted by the National Assembly and disbursing or administering monies appropriated by the National Assembly. I'm sure, Mr. Chairman, you have attended oversight committee sessions in the National Assembly. And why I've mentioned it is that these are clearly activities of the executive that departments of the executive can supervise themselves on. But the Constitution allows the overlap of powers by the legislature to look at what executive agencies of the executive arm of government are doing. So that if there was strict separation of powers, there would not be oversight sessions in the National Assembly. However, the powers so conferred on the National Assembly are exercisable only for enabling it, as it is said, to make laws with respect to matters within its legislative competence and correct any defects in existing laws, expose corruption, inefficiency, or waste in the execution or administration of laws within its legislative competence and in the administration of funds appropriated by it. Thus, in the normal democratic system of government, it is not unusual to see the executive exercise legislative powers by the making of executive orders. They also exercise judicial powers by making subsidiary legislations to authorize its agencies to impose fines on transgressors of the law. See, for example, the powers of the Consumer Protection Council, the Nigerian Communication Commission, and many other federal agencies that have the powers to impose fines on persons that have business to do with them without such agencies being accused of exercising unlawfully or unconstitutionally judicial powers. Also, as stated above, it is not unusual to find the legislature authorized by the Constitution to exercise judicial powers in the course of its oversight functions, either by committing members of the public for contempt of the legislature or sitting and conducting hearings, inviting witnesses to testify before it. I see it as if it is a court of law. The judiciary, on the other hand, also exercises executive and at times legislative functions. Judges propound and make laws within the body of their judgments. I see the local government autonomy case as a lawmaking jurisdiction of the Supreme Court. They award contracts within their domestic responsibilities. Many other numerous examples abound. One other vital matter to note in the matter of the construction of houses for judges within the FCT is that it is not a personal bonanza of the minister of the FCT, but an appropriated project in the budget, which received the assent of the President of the Federal Republic of Nigeria. Consequently, the way and manner the said critics have been going about it as if the minister of the FCT is constructing the buildings out of his own personal purse and doling out largesse, and in his individual capacity is unfortunate. Once this distinction is recognized, it becomes clear that the hallowed office of the judge cannot be corrupted by merely giving to them their entitlement or any accoutrement due to their office. In other words, that because you give the courts, the judiciary, what is their right under the law, does not mean that you are corrupting the courts. It will be too far-fetched to say that. Historically, providing accommodation for judges and or judicial officers dates back from colonial times. We are privy to the knowledge, and our official records and documentation bear us out that judges have been provided housing by the executive arm of government since colonial times in government reservation areas of virtually all urban cities in Nigeria. I know where the judges' quarters are in Zaria, Kano, Ikoyi. Judges have always been provided accommodation, so it wasn't a new thing. This practice was stopped around 2007 when it became government policy to monetize housing and other perquisites of office under the guise that government will be saving more money when it pays rent for housing and buys vehicles for its staff across the three arms of government. The judiciary was the first to back out of this arrangement. I was in the NJC then, because it discovered that the withdrawal of accommodation from judges, especially newly appointed judges, exposed them to danger of having to rent accommodation in anyhow areas of the town, which exposed them and their families to grave danger. Imagine a judge who should be staying in Maitama because of the hallowed nature of his office, now goes to Kuchibena or one of these suburbs because he finds it cheaper there. And one day he comes across somebody who was tried for one violent offense or the other. That one brings his gang to sort of deal with him. Would we say we have saved money by not giving him accommodation where he should be, instead of paying him off and say he should go and take accommodation anywhere? Thus, now that this service is being reinstated by the executive, which is the appropriate agency to carry out such works, some people are losing sight of the big picture and have reduced the matter to one of party politics without considering the overall benefit of the provision of housing by the executive to the safety, independence, and impartiality of the judges in question. Finally, on this point, it ought to be noted that the three arms of government work in tandem and in a coordinated manner. They do not work at cross purposes. Thus, the Constitution expressly vests the function of submitting budgets, executing law, planning for both the legislature and judiciary on the executive arm of government. Moreover, judges are sworn on the holy books, the Bible and the Quran, to dispense justice without fear or favor, or ill will or malice to anyone. One will be thinking very low of our judicial officers if it is thought that their judicial oaths do not count for anything. I have previously extensively dwelt on this aspect of the opening remarks. I have extensively dwelt on this aspect of these opening remarks for the simple reason that quite a number of people, mostly politicians and their friends and advisors, have lost sight of the fact that the judiciary does not exist solely or exclusively for the resolution of electoral or political disputes between politicians inter se. Judicial officers or the judiciary resolve other disputes. And these disputes may be commercial in nature, criminal in form and substance. They adjudicate on and resolve disputes of personal status in the form of chieftaincy disputes, family, contractual tortures, and even constitutional disputes. Thus, political cases are just a microcosm of the variety of cases that the judiciary adjudicates upon. Consequently, if the political class is allowed to destroy the image of the judiciary willy-nilly, then it is the society that will suffer massively for it, and at the end of the day, it might be impossible to return to the status quo. The criminal justice system earnestly needs the judiciary in order to sustain the equilibrium between the society and persons who are prone to disrupt the peace, order, and sanity of the same society. We should not sacrifice the stability of the society, which is hinged on the ability of the judiciary to perform its functions without intimidation, fear, or bullying, on the political altar of very angry politicians and their advisors when they lose cases. In conclusion, I once again welcome you sincerely and indeed very profusely to this year's opening ceremony of the 6th Annual Criminal Review Conference. I wish you a very engaging conference. Thank you very much. I hope I didn't bore you with this opening address.
Let us give our coordinator a resounding round of applause. Every year, I always say that at the opening ceremony, we normally have 2 keynote addresses. One by the coordinator and one by whoever is invited. So let's give him another round of applause. He dealt with very significant issues, and I'm sure we'll all be looking forward to the hard copy or soft copy of the speech so that we can keep in our various libraries. Permit me at this stage to take other recognitions. I saw with us Honorable Justice Celestine Odo of the High Court of Justice. We also have High Court of Justice of the FCT. I'm so sorry. He's our former Director of Magistrates and a friend of the Rule of Law Development Foundation. You're welcome very much, my lord. We also have with us Leonard Sheikh Ruben Atabo, Senior Advocate of Nigeria, here present. You're welcome, sir. Then I was informed that right there in the government house, in the glass house in Kogi State, we're having Hajia Musa Yusuf Alilat, the Permanent Secretary and Solicitor General of Kogi State. Please, let's give her a round of applause too. She's nodding. We can see you, ma. And then we also have your worships. I will get the list of the magistrates that are also attending this program, because the magistrates are also the engine room of the criminal justice system. You agree with me? And they are here. At this stage, I will now introduce the special guest of honor. I've already done so briefly, but before I invite him to give a speech, first, sir, let me congratulate you for the judgment of the Supreme Court on Friday. If that judgment had gone the other way, we wouldn't have been addressing you as executive chairman of the Economic and Financial Crimes Commission. You're very much welcome. I start by introducing our executive chairman, Mr. Olanipekun Olukoyede, who was appointed to this position by the President, Bola Ahmed Tinubu, and confirmed by the Nigerian Senate on October 18, 2023. But before becoming the FCC chairman, he held significant positions within the commission. He served as the EFCC secretary from 2018 and was also the chief of staff to the acting chairman, Ibrahim Magu. He is a thoroughbred lawyer with over 22 years of experience at the bar, as well as regulatory compliance consultant who specializes in compliance management, corporate intelligence, and fraud management. He is a certified fraud examiner with expertise in fraud management, corporate intelligence, and compliance. He has been involved in numerous international anti-corruption efforts, and he has led several investigations and civil litigation of fraud and financial crimes in international development projects. He specializes in anti-corruption research and analysis, corporate and business intelligence gathering and processing. He is also a distinguished academic, having studied in institutions like Lagos State University, the University of Lagos, and most notably Harvard University's Kennedy School of Executive Education. He worked as a lawyer at the law firm of the former Vice President, Professor Yemi Osinbajo, SAN, before he clinched a job at the EFCC. He has also specialized in anti-corruption research, as I said earlier on, in addition to his legal and professional achievements. He is a pastor at the Redeemed Christian Church of God and is very active in his community. He has been a vocal advocate for strengthening Nigeria's anti-corruption framework, including on focus of prevention and improved transparency. He's a member of various organizations, the NBA, Fraud Awareness Group, member of the Society of Compliance and Ethics in the USA. Permit me and give a round of applause as I invite the executive chairman of the Economic and Financial Crimes Commission to give his opening remarks and the keynote speech. You are very much welcome, sir.
Since precedent is something that we owe highly in justice administration, I'd like to follow the precedent, the protocol robustly established by my brother, Mr. P.O.W, Senior Advocate of Nigeria, which has also been adopted by my Egmont, Chief J.B. DAUDU, the coordinator and promoter of this engagement. That will not go without recognizing the presence of my lords, honorable justices here present, and those who are online watching us, both serving and retired. Also the presence of the Honorable Attorney General of the Federation, represented by the Director of Public Prosecution, all the senior advocates of Nigeria here present, esteemed guests. I stand here to speak to this august gathering with a deep sense of honor and privilege, knowing that you represent the finest breed of the legal profession and the judiciary. The history of Nigeria's political evolution is replete with peculiar challenges for the judiciary and the nation itself. This is expected, and is given that the dynamism of the human society manifests in constant challenges that bear down on our institutions. The security and economic challenges that currently confront our nation fall in this category. It is well established, however, and not peculiar as some other nations have passed through similar challenges and emerged stronger. The triumph of these nations over the adversity of security and economic meltdown was down to the ability of the dig deep and mobilize all resources to navigate the mire of strangulating security and economic challenges. So it is therefore against this backdrop that I consider the theme of this keynote, optimizing the administration of criminal justice in Nigeria, and how to navigate emerging and systemic challenges of insecurity and economic hardship as a clarion call. I'd like to thank Chief J.B. DAUDU for championing this cause. And I also like to thank those who have been participating for the past 6 years. Now, given that our society, lives and actions of the citizens are all governed by law, the judiciary is not just at the core of what makes society and the people successful. It is the bedrock. It equally follows that failures of many societies can be linked to the quality of the judiciary and legal systems they operate. By extension, therefore, Nigeria's ability to overcome current and emerging challenges of insecurity and economic hardship is dependent on a robust judicial system that is well alive to its responsibilities, irrespective of what the challenges are in the judiciary itself. senior lawyers, and particularly judicial officers must be of high moral and professional rectitude. The contrary spells hopelessness and doom for our society. Now, looking at the emerging threats of insecurity and economic hardship, for an appreciation of the responsibility which the judiciary shoulders in optimizing the administration of justice in addressing current security and economic challenges, it is important to capture these challenges as they are today. It is no longer a matter of debate that Nigeria has for more than a decade now been experiencing severe insecurity challenge, manifest in banditry, kidnapping, insurgency, farmer-herder clashes, and other acts of violent extremism. These crimes, which used to be limited to parts of the country, are now a nationwide phenomenon, even though the severity varies from one region to another. Apart from the loss of lives and property that are commonplace, the greatest impact of insecurity is on the nation's economy. Nigeria is currently facing the greatest food security threats in modern history on account of insecurity. Farmers are not able to access their farms for fear of being hacked to death by marauding criminals. Also, vast swathes of land in the northwest and north-central regions, rich in minerals, including precious stone, have been taken over by bandits who exploit these minerals and use the proceeds to procure arms against the Nigerian state. The nation's power grid, not efficient in the best of times, have lately come under severe attacks by criminal elements bent on bringing the last leg of the nation's economy down. Under this atmosphere of insecurity, Nigeria's quest for foreign direct investment inflow has been hampered. Only the daring will overlook the bleak security outlook to commit resources in insecure environments. These factors have combined to worsen Nigeria's economic outlook, with the fundamentals still looking bleak despite the strong monetary and macroeconomic policies interventions by the Governor of Central Bank and the Minister of Finance. The value of Naira is still a matter of concern in the face of continued illicit financial flows. On the other hand, tax reforms, measures of President Bola Ahmed Tinubu administration intended to improve earnings outside of the oil industry, is a source of national tension. But amid the ulabalu, the citizen is left holding the long end of the stick, with his fortunes sinking deeper in the mire of economic despair. Now, what should be the response by the judiciary? Why some of the challenges that Nigeria have faced simply blow over, others leave casualties and enduring turbulence on its institutions and citizens. Amidst the turbulence of the current security and economic challenges, Nigerians are looking up to the judiciary and other institutions for support. The judiciary has a long history as a beacon of hope for both the weak and the strong. An impartial arbiter in complex situations, our jurisprudence is replete with such episodes of legal triumphalism in the midst of despair. How have we fared in the current national circumstances? Has the institution of administration of criminal justice actually lived up to expectations of Nigerians in addressing current security and economic challenges? How have we, as lawyers and judicial officers, applied the law in stimulating our economy to grow and prosperity? It is easy to expect some learned minds to argue that it is not the job of lawyers to get the economy out of the woods after all. The nation is blessed with some of the best economic minds to come out of Africa. That may be a valid opinion, but those who hold this narrow view of the law miss the big picture. Law is an instrument that could be used to liberate the society from myriad of challenges that afflict it, be they social, political, or economic. It is the instrument for reform, and as lawyers, we are trained to be problem solvers. Now is not the time to abdicate our responsibilities. Rather, it is a period to rise to the challenge of our calling. The security architecture and the economy need a dependable and efficient judiciary and legal system to maximize their potentials and reinforce the faith of the citizens. Why I crave for such a robust and crusading role on both scores, the evidence available suggests something otherwise. On the security plank, the law has been lukewarm in matters of securing lives and properties, which is the most important task of governance. It is common to hear citizens ask, for instance, how many bandits and insurgents linked to atrocious activities have been brought to justice. Even though of recent time we've been, due to the commitment of the Honorable Attorney General of the Federation, we have been seeing some developments which for us, to us, seems to be positive. The judiciary will be quick to rise to its own defense with the excuse that it cannot convict persons that were not brought before it, or that were not brought without evidence. Still, in the few decisions by court, has not enough message sent in terms of the severity of punishment that reflects society's revulsion of such criminal enterprise. Sometimes the abuse of court process by counsel in the name of human rights enforcement rise the society. This does not in any way demean our commitment to upholding human rights. There is a need to balance the rights of the defendants, after all, in criminal matters, against the collective interest of the security and well-being of our society and of our country. Now, cases involving kidnapping, banditry, and other violent crimes need to be determined expeditiously, and forceful message sent to the perpetrators that their actions will be duly punished in line with the law. Now going to the judiciary and the economy. The situation is worse in terms of judicial support for economic reforms. While we all suffer the pangs of the economic meltdown, people from the perspective of people, they see judiciary as a weapon for pushback by those opposed to the reforms initiated by the government to turn things around. Hopefully, judiciary has been able to maintain their stand in so many cases, and we are proud to say that the modest achievement recorded by AFCC and other anti-corruption agencies in recent times have been largely due to the support and the commitment of the judiciary to do the right thing. So I use this platform to thank the judiciary for doing the right thing and to encourage them to continue to do in spite of the intimidations all around. The Federal Inland Revenue Service is currently buffeted by all manners of attacks on account of the tax reform. And as expected, this matter may still end up in court. The reform in the oil industry is daily confronted by threats of or actual legal action by interest in favor of a return to status quo. The EFCC, for instance, has been at the forefront of efforts to recover stolen funds as part of a larger plan to reinflate the economy. Not surprisingly, the Commission has been under attack by vested establishment interests. The failed challenge of the legal status of the Commission by a coalition of state governors was the climax of attempt to deflate the Commission's anti-corruption efforts. Others include frequent applications by senior lawyers challenging the investigative powers of the Commission, including the powers to invite suspects for questioning. We say this, and that has always been my gospel everywhere I go. The last judges' conference made it very clear, and we want to also thank the judiciary for doing the right thing. And I gave, for example, a live case where an honorable justice in one of the states, Federal High Court, one of the states, made a very, what I call a distressing call to one of my zonal directors at about 11 p.m. one night, claiming that her account was hacked. The money she has put together for 4.5 years to pay her daughter's school fee somewhere outside the country. Overnight, the account was hacked. They stole about 4,000 pounds from that account. So she made a distress call to my zonal director. Incidentally, in that state, there has been a restraining order obtained against us for a couple of years not to investigate and all of that. And state finances, really. And again, if we have to stretch it further, The zonal director made a call to me. Oh God, this is the problem. This is what we are passing through. Incidentally, one of the judges very close to that particular judge was the one who gave a restraining order. So I asked him to tell me not to call me. So she put a call across to me. And she was panting, obviously, on phone. I said, "My Lord, fortunately, we have a restraining order from investigating any matter in your state. So we can't do anything about your matter." "Oh, Chairman, it's not true. Who gave that order? Just give me the name of the judge now." And she made all kinds of. I said, "My Lord, don't worry." Incidentally, eventually, rather, we recovered the entire money for her under 24 hours. And so that drove home the point that you see, when you become a victim of some of these crimes, you understand what it means to be part of the crusade. People see the fight against corruption as between EFCC and the rest of Nigeria. It's not so. See, there's nothing personal. Absolutely nothing personal. I will do my bit, and I will move on. 1,000 EFCC will not solve the problem of anti-corruption in Nigeria. Trust me. I'm a key player, and I'm saying this without the collaboration of the entire populace, entire citizen. How much am I going to do? How much are we going to do? I have less than 5,000 staff. I'm supposed to operate to investigate over 700 MDAs at the federal level, look into the state affairs, 36 states, do 774 local governments. What's the strength of what's my capacity? That's where we need the civil society, we need the judiciary, we need the lawyers to support this crusade. And I've had a situation where a lawyer was scammed. A senior advocate of Nigeria was scammed. He ran to my office, panting. Incidentally, the account to which we trace the money happens to also be an account of another senior advocate of Nigeria, who was acting on behalf of a client to buy property. And so when he came to my office, I said, "Look, the issue of anti-money laundering, compliance, and all that has become a major challenge major issue between me and NBA. So until we resolve that, I won't be able to help you." He said, "No. So on so many occasions, I've seen situations where people oppose what we do become victims. And some of those people you see on TV condemning the FCC, I tell you, most of them they bring petitions to the EFCC because they believe so much strongly that EFCC has the capacity to assist them. So when they become victims, the first place they run to is the same EFCC. And so I said, if according to your desire, EFCC has been proscribed, then where we have run to? And those who are advocating for the proscription of EFCC, have we ever for once given us an alternative? How we are going to get out of this mess? And like I did say, that's really nothing personal. I would have preferred to stay in my house, in my chambers, and enjoy my practice, just like my gun is doing. But unfortunately, these scholars, there's this clarion call on us to do this work. I can't tell you the kind of pressure we pass through every day. I can't share 10% of it with you. Both physical, spiritual attack, all kinds of, media attack and all of that. And that's what is helping us. Don't worry. So we need to come together on a serious note. Like I told the National Assembly members when they visited me, some of the challenges we are facing and some of the things we have discovered. So complaining about issue of power and electricity. I told you some of the things we have done, some of the things we discovered. And some people say, "You haven't discovered that. What have we done?" And I asked them, "Are you not aware that there was former Minister of Power that we are out prosecuting, that I arraigned 3 months ago? And some establishment people. Look, you need to see what this establishment people, the people we call establishment people? The real civil servants. Some of them do worse than our political leaders. And we're not going to spare them. We're not going to spare them. There is no political leader that can steal successfully without the support of the establishment people. They teach them into intricacies. They teach them how to cover up. So when I arraign the minister, I also arraign directors, I arraign the deputy director, assistant director, up to clerk. The matter is in court. And so it's a collective responsibility. As I begin to bring my presentation to a close, we now have a situation where some institutions have secured for themselves judgment which states that the anti-corruption agencies cannot investigate and prosecute them without the consent of their institution. With this trajectory, I'm afraid that we may soon have a situation where an Agbero, you know what Agbero is? We say it cannot be invited by the EFCC without approval of NURTW. Now, it's a major problem. Without prejudice to the pronouncement of the court, it is important for us to understand that when we have a major challenge facing our country, about trust to our development, it is important for us to also devise drastic approach to get out of it. Go down history lane. Look at countries that have successfully gotten out of this mess that we find ourselves. At some point in their national life, they adopted drastic measures. And some of them still adopt drastic measures. Death penalty for corrupt officials. There are countries you go in the world, if you steal $1, the sanction is death. Because of the nature of the problem they are facing. And so we cannot, now you come to Nigeria, who is, at the end of the day, who is even the corrupt? Even somebody that has stolen money, that we have indicted, that is already in court. We'll also be saying that Nigerians are corrupt. How are we going to get out of this mess? So everybody is a saint. Now, who is corrupt? And I keep telling people, even to the corrupt, do you really maximize the enjoyment of the process of crime? I say it everywhere I go. You have stolen money, you bought a Rolls Royce, you bought a Lamborghini. Where is the road in Nigeria to drive a Rolls Royce? You've stolen money, you built a mansion in your village. How many times have you gone to that place to sleep with your eyes closed for 1 week? For the fear of insecurity. So we are also the victims. And we must come together as a nation. And what I propose is that we are still going to have it. There is no time, we cannot run away from it. We are going to probably, that's one of the things that will be subject of discourse, shift in this engagement. Let us have a national summit on financial crimes and corruption. Let us see, because it's a major problem. Some of the things we see, we can't share with people. We just give you a tip of some of those stuff. Do we come together and say, going forward, do we either grant amnesty to those who have stolen, bring this money, when you bring it back, we grant amnesty, going forward, don't do it anymore? Or do we say those I'm prosecuting, let them agree, plea bargain, bring all, without leaving anything, bring all what you have stolen, release it to the state, we'll apply some fine, and strictly one going forward, don't steal anymore. But doing that, do we agree to have what we call death penalty for those who will be caught going forward? Because it's a major challenge, it's a problem, it's everywhere. It's everywhere. It's in the executive, it's in the legislature, it's in the judiciary, it's in the legal profession, is everywhere. We have had calls to convict senior advocates of Nigeria. We have had calls to convict ex-governors. We have had calls to convict military people. Everywhere, professionals. Lawyers are they are like, you know, they give support so indirectly, tactically. We call them gatekeepers, accountants, real estate agents. We must speak truth to ourselves if we want to get out of this mess. We have seen a situation where, look, what I need most is the support. If I get the support of the lawyers, the reasonable extent that we want it, and the judiciary, all this, in 6 months, we'll sanitize Nigeria. That's the truth, in 6 months. And I tell the lawyers, particularly senior lawyers, I said, do you even know that because of the endemic nature of corruption in Nigeria, is depriving you of beautiful briefs that would have come to you? And I give you an example. Most foreign direct investments that are coming to Nigeria, they come with their counsels. They come with their foreign lawyers. That's the truth. They just look for one local Nigerian lawyer to have some prominence to team up with their foreign lawyers. They don't do anything exclusively with local lawyers. It's not a palatable story to share. When we have senior advocates in Nigeria, you bring lawyers who have less than 15 years experience to come and drive your investments here. They don't trust us.
They don't trust us. Look at all the arbitration clauses in all the major agreements, concessional and all of that. They take it to London Institute of Arbitration, Court of Arbitration. Not even Nigeria. Investment in Nigeria. So we must speak truth to ourselves. Nobody's going to clean this system. We cause it. We brought Nigeria to the knees, and we will take Nigeria out of the dooms. Nobody will do it for us. And it's a thing that must drive our discussion, subject that must drive our engagement because of this program for the next few days. Now, this attempt to emasculate the powers of the law enforcement agencies have the dire consequences of discouraging foreign investment due to the wrong signal it sent regarding the stability and efficacy of the rule of law framework in the country. If lawyers have no scruples challenging the legality of EFCC, what do we expect from them in respect of the ongoing reforms in the capital market in respect of trading in virtual assets? The Security and Exchange Commission is working with stakeholders to bring this sector that controls billions of dollars in transactions outside the financial system under regulation. This cannot be achieved without a buy-in and support of the lawyers and the judiciary as well. Very quickly, the reforms that are needed. At no point in our contemporary history have judicial officers been put through crucible and firing line as they have in recent past. This points in the direction that those who fight monsters can in the process become monsters themselves. No mega financial fraud, especially illicit financial flows, is possible, and I say it's possible, without lawyers. The transfer of huge funds into offshore accounts, preferable in tax haven, are aided by lawyers. This is by virtue of the contemporary evidence I have, facts and figures, statistics. If I have time, I will share some of them with you. Now, this transfer of huge funds into offshore accounts, preferable in tax haven, are aided by lawyers. The most traumatic discovery of the FCC in recent years was the subjugation of national interest and well-being to personal interest by lawyers, who aided briefcase foreign investors to fleece the nation in dubious transactions. Of course, you remember the case of P&I scam, Mambila Power Project, Sunrise. Most of these cases are in court. So these are empirical facts and evidence that we can present before you. While the FCC has had cause to prosecute judicial officers and senior lawyers and earn conviction, my respect for the bench and senior members of the bar remains undiminished. However, based on the unique experiences of the EFCC in the prosecution of corruption cases, I'm particularly interested in systemic reforms in our justice delivery system that capture the following. Number one, the process for the discipline and regulation of judicial officers must be reviewed to reflect that we are actually in a deep shit and we need to get out of it as quickly as possible. The regulation and discipline of legal practitioners. Now, I say this because of what happens across the globe. For whatever EFCC does, we are quick to point at FBI, to point at NCA and other law enforcement agencies and compare us with them. And I tell you, these people you are comparing us with, we have had cause to work with them. They have had cause to carry out joint operations with us, and they have had cause to drop their hearts for our level of commitment and professionalism. For the first time in the history of EFCC, about 4 months ago, the director of FBI came visiting me for the first time in the history of EFCC. We took him to the villa to see the president. He was with me for 2 days. We were trying to compare notes. Commended us, issued a public statement when he got back to the US. Gave some of my staff award for the joint operations we have carried out. And attested to the fact that EFCC is an anti-corruption agency that they are proud of, that they can work with. In the same vein, a month after, the Director General of NCA came to my office, expressing solidarity and support. We have had cause to work together, and we are still working together. As sometimes we are too fast and too quick to destroy our own system. People will sit before the TV and run down the EFCC. Say EFCC has turned to, debt recovery agency. They hound people, all kinds of allegations. And I look at people and sometimes I shake my head. Legal minds, people that you expect them to know more. Some people will give statistics, allude to issues that they don't have basic knowledge about. It just could have been a matter of coming to our office, putting a call across to us. And we would have explained to you some of these things we're doing, what informs certain decisions. We are human beings that blood runs in our veins. We have soul. We can't sit there in that office and begin to run things the way we... No. And I tell people, for me as a person, I'm not just sitting there as the chairman of AFCC. I've been on the other side. I've been subjected to investigation myself for 2 years. So I know what it means to subject people to investigation. When I was secretary of AFCC, some of you knew about it. What is important is that, look, what we are doing, like I said, my major policy objective is to use the instrumentality of this mandate to stimulate the economy and to also follow the rule of law. And I've challenged on so many fora. If you give me one judgment that I'm aware of, that EFCC we have refused to obey. Yeah, I can't speak for all the staff of EFCC, but just bring it to my attention. There was something that looked like a ridiculous judgment that some people are, parading all over the place. So my Chief DAUDU got it and he forwarded it to me. I think that was a few days ago, sir. And by the time I sent the true position of things to him, he was surprised. He said, "Oh, is that?" People said we have entered into plea bargain and we collected 290 million naira as against 30-something billion that somebody has stolen and all that stuff, and which is not true. By the time I responded, stating the fact, what happened, he was shocked. So if you had not taken the pain and the sense of responsibility to confirm from me, that was how probably somebody of his status would have also flowed with that erroneous thought. So it is important for us. You don't expect me to be coming to the TV to be, announcing everything we do. No, it takes people who are reform-minded to work with us, to know what we are doing, and to help us, to support us. So the work of lawyers cannot be overemphasized. And sirs, we have seen situations where, in other crimes, a lawyer will tell a suspect or a client that this thing that you have done is wrong. You have seen a situation here where an ex-white governor was tried in Nigeria, discharged. The matter got to the UK. He went to meet with one of the finest defense attorneys in the UK. And they look at the case file. They got our proof of evidence, but the matter was investigated in Nigeria. And they said, he told the man, he said, "Look, if I should defend you the way you want me to defend you, I will lose my license. I'm not going to do this. I will advise you to go and plead guilty. Let's see how we can amend some of them, to plead guilty, talk to the CPS and all of that. Let's see how we can be on the same page. Plead guilty. Probably they will reduce your sanction and we'll move on." He said, "No, back in my country, I've been discharged over the same allegation, same proof of evidence, same facts." Incidentally, I know that particular lawyer. I had a meeting with him because I wanted to do a few things for us. Now, the lawyer said, "Look, they told him that if you are not taking my advice, we encourage you to look for that defense counsel. So we are going to return the case file to you. But when you are going, we are going to also do a note to whosoever you are going to meet. And we will tell the other counsel why we are rejecting your brief. That we gave you an advice to plead with and you refused." He said, "No, do we have to do that?" They said, "Yes, we have to do that." And so he went, consulted with some other lawyers, and they advised him, he said, "Look, if that man can't defend you, successfully, no other person can do it. That's the finest defense attorney we have in the UK." So he was forced to go back. And the lawyer encouraged him to plead guilty. Me and you will know the result of the case. We knew the judgment. We knew the end point. Why can't we do the same thing in Nigeria? You have seen somebody. Look, I dropped my hat with one of the senior advocates of Nigeria who came to me about a month ago. One of the people we are prosecuting, defendants, approached him. "Come and defend me in this case." And he said, he looked at the case, he spoke to one of my investigators and all of that. And he told me himself, so he told the man, you can't take your brief because this is a bad case. That is a lawyer, a senior advocate in Nigeria who deserves respect, who knows all his honors, who knows that everything is not money. When we talk of integrity, so we need integrity even to survive as a legal practitioner. This thing we call integrity is not just about law. It's not your ability, your advocacy ability to write beautiful briefs, to get people off the hook. No. It's a mix of law and morality. And your conscience must tell you to do the right thing. That's what integrity is all about. And I tell you, there are people, senior advocates, that will invite me for this kind of program. I will not come. I won't honor it. As a matter of fact, I had 2 invitations this year from senior advocates. I didn't go. I didn't honor it because I didn't believe in that they share the same mandate with us. I didn't believe that, they're on the same, they have this, they are reform-minded and they want Nigeria to be better. I don't believe in it because of what we have seen. So finally, ethics, values, and standard of legal practice must also be reviewed. These are essential to me because the job of EFCC is ensuring that the corrupt does not find space in our national life. And when they do, to make them pay for their deeds. It is for this purpose that I also wish to urge you to address the issue of obscene legal fees by senior lawyers, particularly the one they earn from political office holders, and particularly the manner in which they collect such fees. I don't have any problem with what you charge political leaders, but I have a problem with the way the money is collected. If a lawyer would not care about the source from which a sitting governor or any other public servant pays him millions of naira to defend him in an electoral tribunal, the lawyer must necessarily be mindful of the fact that the only proper way to collect such humongous amounts is through the financial system. Aside from violating money laundering regulations, hauling millions of naira professional fees from public office holders in liquid cash. In fact, they don't even collect naira anymore now, they collect dollars. So that we'll be able to carry it. As senior lawyers do, is only aimed at tax evasion, running contrary to anti-money laundering regulations and laws. It is needless to stress that the best act of mentoring from leaders of the bar to the younger generation of lawyers is by living out the ethical demands of the professional, of the profession. I'd like to thank you immensely for the opportunity you gave me to share my thoughts, and also let this highly respected audience know that what we call criticism, constructive attack on us is welcome. I've never been averse to that, never. But let us do it in a responsible way. Some of our practitioners, Nigerians who practice in the UK, will know that they can't sit down and run down NCA. They won't do that. They won't get away with it. They won't get away with it. What do we benefit from running down our institutions? If you notice EFCC is doing anything wrong, come to us. We'll sit down and I will explain some reform agenda, some of the things we are carrying out. Upon my assumption of office, we have put some reform agenda in place. We have reviewed our arrest and detention policy. I've had cause to investigate a whole ministry, ministers, DGs, and all of that, without detaining anybody overnight. And I got all the information I got. I got all my documents. I got everything, and the matter is going on fine, without detaining a single soul. But that does not foreclose the need that if there is need for us to detain, you should not detain. It may be lawful, it may not be expedient at some point. We have also had cause to now equip all our interrogation rooms. So when you come now, we have started interrogation rooms in compliance with the judgment of court. Also, I need to know, and to also let you know, that the era of 100 can't charge, 150 can't charge, 85 can't charge is gone forever in the EFCC. I've given a standing directive. No prosecution will be more than 50 can't charge. What are we, if your case is watertight? That's why I will never rush to court. If I'm not sure of the proof of my evidence, never. I get case files myself. So it's not just about asking lawyers. I vet case files myself, particularly high-profile cases. And I agree with the lawyer. You must give me a draft of charge. We'll look at it together, compare it with my proof of evidence, sleep over it before I give my go-ahead to go. Because I don't want to lose any case. Of course, you can lose it, but again, don't let it be on ground of lack of diligent prosecution. If there are other technical issues, fine. But I will be sure that I've done my job. And I've done it in such a way that I can defend long after I leave office. So many other reforms agenda is going on. The issue of our staff, corruption and all of that. Just 2 weeks ago, I had to dismiss 2 staff. You can't be fighting corruption and your hands are dirty. Say who comes to equity, your hands must also be clean. And I said, I will not only be dismissing them, I will also be prosecuting them. But that's what we prosecute others for. So you will see that we are preparing some case files now to prosecute some of the people I've dismissed. We're going to do that. If an EFCC staff will not be able to stand publicly with his shoes hand up and challenge the entire public, whose goats have I collected? Whose bottles of water have I taken illegitimately? And I say to Nigerians, if ever influenced me, giving me 1 dime because of my work, come out and say it. I stand to be challenged. If I'm owing anybody a bottle of Coke because of my profession, come out and say it. So I can't be easily influenced by things like that. That's why we must make up our mind, work together to do the right thing. Any staff that is corrupt, I will show you the way out. Because how do you want the public to look at us? Again, you know that some people want to be over-serious. Out of every 12, you must have 1 Judas. So you can't say, I can't stand there and say, oh, all is good, all is perfect. No. As many as you see, report them to us. And we'll do justice. And I want to say thank you to this audience and also my Egbon who has put this program together. I wish you success with the conference on criminal law review. And I pray for you, sir, that the grace you need to see all the solutions that will be taken or put together in this program, to see it through, to see it well implemented. Also, I will not pray for more money for you. I will not pray for more financial prosperity. You are already rich. You have money already. So I only pray for long life for you, pray for good health, and to all the participants. Thank you and God bless you.
Please let us give our executive chairman of the EFCC another sounding round of applause. You agree with me, he spoke passionately. First, as a concerned citizen of Nigeria, and spoke to us particularly to invoke moral principles out of us and ensure that in the quest for a better Nigeria, we look at ourselves. I'm also happy that he was very forthright in his views and challenged us too, as not only legal practitioners, but as citizens, to always do the needful, ensuring that corruption is weeded out. It is indeed a hydra-headed monster which he has identified. And he identified the enormity of the challenge the FCC is facing. On behalf of the Rule of Law Foundation, we continue to pray for you for strength, sir, in this fight. God will continue to keep you. Now, we move on to goodwill messages. And the first goodwill message will be taken by the Honorable Attorney General of the Federation, ably represented by the Director of Public Prosecutions. Please, let's give him a round of applause. Permit me to also recognize U.O. Sule, Senior Advocate of Nigeria, who is here present. Let's give him a round of applause. And Wale Balogun, Senior Advocate of Nigeria. Let's give them a round of applause, please.
Thank you. The Coordinator, Rule of Law Development, Chief J.B. Daudu, SAN, the Chairman of the Economic and Financial Crime Commission, Mr. LOKOJA, my lords here present, Leonard, Senior Advocate of Nigeria, good morning. I represent the Honorable Attorney General of the Federation, who wanted to be here personally to grace this occasion, but for demands of urgent state matters. He sends his apologies. I'll read his remarks. I am delighted to be here today amongst this august gathering of legal minds, policy makers, law enforcement officials, and other stakeholders who are committed to advancing the cause of criminal justice and security in our dear nation. I commend the conveners of this conference under the theme of optimizing the administration of criminal justice in Nigeria, how to navigate emerging and systemic challenges of insecurity and economic hardship. The perilous global and national security situation makes this conference both crucial and timely. Our nation stands at a critical juncture where insecurity and economic adversity present profound challenges to the rule of law and the administration of justice. These challenges demand innovative, practical, and collaborative approaches to ensure that our justice system remains robust, fair, and effective. The federal government, under the leadership of His Excellency President Bola Ahmed Tinubu, is committed to reforming and strengthening our criminal justice system. We are taking decisive steps to address the root causes of crime, improve law enforcement capabilities, and enhance the efficiency of our courts. Today, as we navigate some of these pressing issues, allow me to highlight three key areas of focus: the need to strengthen institutions and legal framework. The Administration of Criminal Justice Act 2015 and its corresponding state laws provide a strong foundation for expediting justice delivery. However, consistent implementation, capacity building, and periodic reviews are vital to adapting to the evolving nature of crimes, including terrorism, cyber crimes, and organized economic offenses. 2, the need to leverage on technology and innovation. Modern challenges require modern solutions. Leveraging technology in policing, evidence gathering, case management, and judicial processes will enhance efficiency and restore public confidence in the justice system. And 3, the need to foster collaboration and build public trust. Addressing the twin scourge of insecurity and economic hardship requires a multi-stakeholder approach involving government agencies, the judiciary, civil society, and the public at large. Transparent communication and adherence to principles of justice and equity will build trust and foster a shared commitment to societal stability. As custodian of law, we have a collective responsibility to ensure that justice is not only done, but seen to be done. This conference provides an excellent platform to deliberate, share ideas, exchange experiences, and develop strategies to address the challenges we face as a nation. I encourage all participants to engage in constructive dialogue and commit to actionable solutions that will drive the optimization of our criminal justice system. I assure you of the unwavering support of the federal government as we work towards a safer, more equitable, and prosperous Nigeria. Together, we can transform challenges into opportunities for lasting progress. Thank you for your attention. I wish us all a fruitful deliberations. Thank you.
Thank you, the Honorable Attorney General of the Federation. Let's give him a round of applause. Ably represented by our own DPP. We move swiftly on because we want to round this session before 12 noon. We take the next goodwill message from the President of the National Industrial Court of Nigeria, ably represented by Honorable Justice Anue. Please, your goodwill message, my lord. Most grateful.
Good morning, everyone. I bring greetings from the President of the National Industrial Court. He is unfortunately not able to be here today, but he has asked me to read his goodwill message, and I'll proceed straight to it. Meanwhile, I would like to stand on existing protocols as established by my big brother, the learned Silk, the coordinator of the Rule of Law Development Foundation. And I must acknowledge all my lords here present and learned Silks here present, ladies and gentlemen. Now to the goodwill message. When I received the letter inviting me to this year's Rule of Law Development Foundation's 6th Annual Law Review Conference with the topic, Optimizing the Administration of Criminal Justice in Nigeria, how to navigate emerging and systemic challenges of insecurity and economic hardship, I could not but pause to reflect on the many challenges bedeviling our criminal justice system, especially in this period of dire insecurity challenges and severe economic hardship. Therefore, the best time to have discussions on how to navigate through the issues of security and economic hardship is now. It is for the above reason that I express my deepest delight to be present at this year's conference. I sincerely appreciate the Rule of Law Development Foundation for the invitation extended to me to attend this event as special guest and to deliver a goodwill message. I salute the leadership of the Rule of Law Development Foundation for their resilience in championing an initiative of this magnitude aimed at advancing a nation's criminal justice system which safeguards its rule of law. My special commendation goes to the initiator of the Rule of Law Development Foundation, Chief J.B. DAUDU, SAN. I refer to him as the brain box of the rule of law and criminal justice. His contributions are invaluable and unquantifiable. There is no doubt that the Rule of Law Development Foundation works to strengthen access to fair criminal administration systems, as well as promoting and encouraging legislative advocacy skills within the ambit of the rule of law in Nigeria, Africa, and the world. The foundation has made great strides towards reforming the justice sector. The Administration of Criminal Justice Act 2015, ACJA, is unmistakably a significant legislation in enhancing efficiency and effectiveness in the justice delivery system in Nigeria, particularly in expediting criminal trials, the congestion of the correctional centers, and the protection of the rights and interests of marginalized persons. However, insecurity and economic hardship poses a serious threat to the implementation of the provisions of the Act. Notably, the ACJA aims to shift the criminal justice system from punishment-based to restorative justice, which prioritizes the needs of victims, vulnerable people, and human dignity. The general tone of the Act puts human dignity in the fore, from the adoption of the word defendant instead of accused, to its provision for humane treatment during arrest, speedy trials, suspended sentencing, community service, compensation for victims, and so on. However, economic insecurity alongside poverty and inequality poses a serious challenge which is faced by citizens in Nigeria today. Over the years, unemployment, low income, inflation, loss of investment, food security, and illiteracy have contributed to national instability as well as internal security, which have had adverse impact on the economy. In order to achieve peaceful coexistence within its borders and further its goals of addressing insecurity, combating corruption, and enhancing the welfare and standard of living of its citizens, a country must be protected from both internal and external aggression. Let me mention that a functional criminal justice system is aimed towards the maintenance of law and order in society by punishing those who break the law and protecting the welfare of the citizens. This system ensures that suspects are appropriately investigated, prosecuted, and defended to guarantee a fair trial. Criminal justice is a multidisciplinary system that involves various fields such as law enforcement, the judiciary, and correctional centers. This system ensures that suspects are appropriately investigated, prosecuted, and defended to guarantee a fair trial. One of the primary goals of the criminal justice system is to reduce crime, and this is achieved through rehabilitation, deterrence, and incapacitation of criminals. Effective and efficient administration of a criminal justice system will be nearly impossible without security and a thriving economy. Moreover, the social and economic advancement of a country is hampered by an inefficient criminal justice system because it is unable to safeguard the marginalized people who may turn to violence and crime. To ensure that everyone has access to justice and to create inclusive, responsible, and efficient institutions at all levels, the idea of optimizing the provisions of ACJA in Nigeria is essential. Ensuring fair access to justice, bolstering institutions free from corruption, and fostering peaceful societies are the objectives of the criminal justice system. I commend the Rule of Law Development Foundation for being at the forefront of the struggle for the promotion and entrenchment of the rule of law in Nigeria, Africa, and the world. It has remained resilient in safeguarding the rule of law and advocating reforms to advance the justice sector. Issues relating to the rule of law are key to peaceful existence of any society and very relevant to its socio-economic development. The rule of law fosters development through strengthening the voices of individuals and communities by providing access to justice, ensuring due process, and establishing remedies for the violation of rights. The concept of the rule of law is fundamental to the promotion of peaceful and inclusive societies for sustainable development, provision of access to justice for all, and building effective, accountable, and inclusive institutions at all levels. Hence, in order to achieve peaceful coexistence within its borders and further its goals of addressing insecurity, combating corruption, and enhancing the welfare and standard of living of its citizens, a country must be protected from both internal and external aggression. Without adequate security and a strong economy, the rule of law cannot be enforced. The rule of law represents a principle of governance that all persons, institutions, entities, public and private, including the state itself, are accountable to laws that are publicly promulgated, equally enforced, and independently adjudicated. Therefore, the rule of law ensures equitable access to justice, strengthens corruption-free institutions, and nurtures peaceful societies. In order to prevent people from becoming a menace to society and to make sure that justice is carried out in certain situations, equal access to justice is essential. The rights of vulnerable groups such as women, children, and marginalized communities are protected by an efficient criminal justice system, which also makes it easier for them to obtain protection and essential services. Additionally, a successful implementation of the ACJA will support effective management of criminal justice institutions, prompt justice administration, crime prevention, and the defense of the rights and interests of suspects, defendants, and victims. It is a known fact that democracy only thrives where administration of a good justice system is properly entrenched. That is why the topic for this year's conference, which is tagged Optimizing the Administration of Criminal Justice in Nigeria, How to Navigate Emerging and Systemic Challenges of Insecurity and Economic Hardship, is apt and couldn't have come at a better time. Administration of Criminal Justice System, a pivotal aspect of the rule of law in Nigeria, focuses on the leadership and operations of the various aspects of the criminal system, such as the courts and law enforcement, which work together to help prevent and punish crime. It is therefore existential towards ensuring peaceful societies where laws are respected and fairly applied. It further fosters an environment of security and stability. It deters violent conflicts, promotes human rights, and encourages social and economic development. It is to this end that I commend the Rule of Law Development Foundation for organizing this conference where issues aimed at revitalizing the administration of justice, not just in the FCT, but in Nigeria as a whole, will be discussed. I equally seize the opportunity to commend all the stakeholders that have thought it necessary to organize this workshop, as well as all the participants here present and those participating remotely. Let me particularly applaud the Rule of Law Development Foundation for its unmatched and unwavering commitment towards ensuring that the rule of law is not only entrenched in the administration of justice in Nigeria, but are also equitably practiced. Today, as we partake of this robust forum, which boasts of notable personalities, I urge everyone present to pay attention to the fine points that will be highlighted. In conclusion, ladies and gentlemen, I cannot afford to further take more of your time, having fully recognized that this is not an occasion for long speeches. Once again, I congratulate the Rule of Law Development Foundation and all participants. On this occasion, I wish you all happy and hitch-free deliberations. As I wish us the very best of experience at this conference, I leave you with this, quote and unquote, viable administration of justice system is a veritable panacea towards combating challenges of insecurity and economic hardship. Let us make it grow. Thank you all for listening.
Let's give my Lord a resounding round of applause. I will extend our warmest regards to the President of the Court. He has always been one of our supporters. We also have a few more goodwill messages before we round up. Technical, please, can you confirm that the President of the African Bar Association, Ibrahim Edi Mark, is online? If he is, can we take his goodwill message before we also prepare to hear in LOKOJA from the Honorable Attorney General and Commissioner of Justice for KOGI State? Those are the two persons I have lined up. Permit me to recognize Professor Remi Akujobi, our head of the rapporteur team from the Federal University of LOKOJA. You're very much welcome, Prof. So, technical, can we take the President of the African Bar Association? Mr. Mark, can you hear me, sir?
Yeah, I can hear you.
Okay, you can proceed, sir, with your goodwill message. You're welcome. So let's give him a round of applause, please.